I was drinking my morning coffee on the porch of my 1887 Victorian home in Savannah, Georgia, when I saw her marching up my walkway with a clipboard and the kind of determined scowl that could curdle milk. Her name was Margaret Henderson, president of the Magnolia Heights Homeowners Association, and she had that look middle-aged women get when they've decided someone needs to be put in their place. I had only been living in this historic house for 6 months, and this was her third visit. "Mr. Sullivan," she called out before she even reached the steps, her voice sharp enough to cut glass. "We need to discuss multiple violations of the HOA covenant." I set down my coffee cup and stood, straightening to my full 6 feet. "Good morning, Margaret. What seems to be the problem now?" She stopped at the bottom of my porch steps, her perfectly manicured fingernails tapping against the clipboard. Her blonde hair was styled in what I called the classic Karen cut, shorter in the back and angled toward the front, and she wore a pastel pink cardigan despite the Georgia heat already climbing into the 80s. "The problem," she said, emphasizing each syllable, "is that your property is in complete violation of Section 12, Paragraph 4 of our community standards. These shutters are the wrong color, your fence exceeds the permitted height by 4 inches, and you have placed historical markers on your property without board approval." I felt my jaw tighten. "Margaret, this house was built in 1887. It's on the National Register of Historic Places. Those shutters are original to the house, and that fence has been here since 1892. I don't care if George Washington himself built this house," she snapped. "You signed the HOA agreement when you purchased the property. The shutters must be painted colonial blue or white, not this dark green. The fence must be reduced to exactly 6 feet, and those bronze plaques must be removed immediately." I took a deep breath, trying to keep my temper in check. The historic Savannah Foundation specifically designated this property as a landmark. The shutters are painted in the original color based on paint analysis done by restoration experts. The fence height is grandfathered in under Georgia historic preservation law. Margaret's face flushed red. "The HOA supersedes any historical designation. You have 30 days to correct these violations or face a fine of $500 per day, per violation. That's $1,500 daily, Mr. Sullivan." She thrust a printed notice into my hand and turned on her heel, marching back down the walkway. I watched her go, feeling a familiar anger rising in my chest. This was exactly why I had left my corporate law job in Atlanta to restore historic properties. I had bought this house specifically because it was a landmark, spending over a year researching its history, and another 6 months carefully restoring it to its original grandeur. I walked back inside, the morning's peace completely shattered. My home was a masterpiece of Victorian architecture, featuring original heart pine floors, 12-foot ceilings with ornate plasterwork, and 6 working fireplaces with hand-carved mantels. The shutters Margaret wanted me to change were made of cypress wood and had been painstakingly restored by a craftsman who specialized in 19th-century joinery. The fence was wrought iron, forged by the same blacksmith who had created the famous gates at Bonaventure Cemetery. I pulled out my phone and called my friend Daniel Morrison, who worked as the director of the Coastal Georgia Historical Society. He answered on the 3rd ring. "Jake, what's going on?" Daniel's voice was cheerful, completely unaware of my morning ambush. "I need your help. The HOA is coming after my house. They're claiming violations because the shutters aren't their approved colors and the fence is too tall." There was a long pause. "They're trying to force you to alter a registered historic landmark." That's exactly what they're doing. "They gave me 30 days or they'll fine me $1,500 per day." That's completely illegal under Georgia code, Daniel said, his voice hardening. Historic landmarks are protected under state law. The HOA agreement can't supersede that protection. Have you contacted the State Historic Preservation Division? Not yet. I just got the violation notice 10 minutes ago. Don't touch anything on that property. Don't paint a single shutter. I'm going to make some calls. Can you scan and send me that violation notice? Absolutely. Jake, this is serious. If they force alterations to a registered landmark, there could be federal implications. Your house isn't just on the state register, it's on the national register. That means federal protection. I felt some of my anger transform into determination. Good. Because I'm not changing a damn thing. After hanging up with Daniel, I spent the next hour photographing every inch of my property and documenting the original features. I pulled out the thick binder I had compiled during the restoration process, which contained historical photographs, architectural surveys, paint analysis reports, and letters from the historic Savannah Foundation certifying the authenticity of the restoration work. The house had originally been built by Captain James Sullivan, a shipping magnate who had made his fortune in the cotton trade. Yes, we shared a last name, which was actually one of the reasons I had felt such a connection to the property. The house had remained in the Sullivan family until 1943, when it was sold to a doctor who converted it into medical offices. By the time I bought it in 2025, it had been vacant for 5 years and was in terrible condition. I had spent close to $400,000 on the restoration, using period-appropriate materials and techniques. My phone rang around 11. It was Daniel again. I just got off the phone with Rebecca Chen at the State Historic Preservation Division. She's livid. Apparently, this isn't the first time this HOA has targeted historic properties. They tried something similar with the Thornton house 3 years ago. What happened with that case? The homeowner caved and painted over original 1850s wallpaper. By the time SHPD found out, the damage was done. Rebecca wants to prevent that from happening again. She's going to send you a formal letter citing the specific statutes that protect your property. She's also going to contact the HOA directly. Will that be enough? It should be. But Jake, you need to understand something. HOAs can be incredibly stubborn, especially when their authority is challenged. This Margaret woman sounds like she's not going to back down easily. Neither am I. The next day, I received an email from Rebecca Chen at the State Historic Preservation Division. The letter was comprehensive, citing Georgia Code Section 441024, which explicitly protects historic properties from HOA restrictions that would compromise their historic integrity. It referenced federal protection under the National Historic Preservation Act and included specific case law where courts had sided with landmark property owners against HOA covenants. I printed 3 copies, one for my records, one for the HOA board, and one for my attorney, just in case. Then I drove to the HOA office, located in a bland strip mall on the edge of our neighborhood. The office was exactly what I expected. Beige walls, motivational posters about community standards, and a reception desk manned by a woman in her early 20s who looked thoroughly bored. I need to submit this response to a violation notice, I said, handing her the envelope containing Rebecca's letter and my detailed rebuttal. She took it without much interest. I'll make sure it gets to the board. I'd like a receipt showing I delivered it. She sighed but printed out a time-stamped receipt. I thanked her and left, feeling slightly more confident. Surely once the board saw that state and federal law was on my side, they would back down. I was wrong. 3 days later, I received a response from Margaret, this time sent via certified mail. The letter was even more aggressive than the first notice. "Dear Mr. Sullivan," it read, "we have reviewed your response and the letter from the State Historic Preservation Division. While we acknowledge the historic nature of your property, the HOA covenant is a legally binding contract that you signed upon purchase. Historic designation does not exempt you from community standards. Your violations remain in effect. You now have 27 days to comply or face daily fines as previously stated. Additionally, we are adding a fourth violation for failure to maintain approved landscaping. Your front garden contains non-approved plant species. All landscaping must conform to the approved plant list provided in your welcome packet." I read the letter 3 times, my blood pressure rising with each pass. They were actually doubling down. Not only were they refusing to acknowledge state law, they were adding more violations. The landscaping complaint was particularly absurd. I had planted a historically accurate Victorian garden using plant varieties that would have been available in the 1880s. Old roses, hollyhocks, foxgloves, and heritage herbs. I had worked with a landscape historian from the University of Georgia to ensure authenticity. I called Daniel again. "They're not backing down, they're adding more violations." "What?" I could hear the disbelief in his voice. "What's the new violation, my garden?" "They're saying the plants aren't on their approved list. Your Victorian heritage garden, the one that was featured in Southern Living last month. That's the one." Daniel was quiet for a moment. "Jake, I think we need to escalate this. I'm going to reach out to the National Trust for Historic Preservation. This has gone beyond a local dispute. They're essentially threatening to destroy a nationally significant landmark. Do what you need to do. I'm also going to call my attorney." My attorney, Patricia Zhang, was a property law specialist I had worked with on the house purchase. When I explained the situation, she let out a low whistle. "They're playing a dangerous game," Patricia said. "HOA covenants aren't absolute. They can't override state and federal law. But here's the problem. Fighting this could get expensive. We might need to file for an injunction, possibly take them to court." "How expensive are we talking?" "Could be $20,000, $30,000 in legal fees if it goes to trial. Maybe more if they drag it out." I felt my stomach sink. I had already stretched my finances to the limit with the restoration, but I couldn't let them destroy the work I had done. "Do whatever you need to do. I'm not backing down." "That's what I like to hear. I'll start drafting a response. In the meantime, document everything. Every interaction, every letter, every conversation. If they show up on your property, record it if Georgia law allows." Georgia is a one-party consent state for recording, right? "Correct. As long as you're part of the conversation, you can record it." Over the next week, things escalated quickly. Margaret started showing up at my property unannounced, taking photographs and measurements. On Tuesday, she brought 2 other board members with her. A man named Richard who wore polo shirts in various shades of beige, and a woman named Susan who seemed to exist solely to agree with everything Margaret said. I watched from my front window as they walked around my property, Margaret gesturing emphatically at various features. At one point, she actually tried to measure my fence with a tape measure, despite the wrought iron spikes making it difficult to get an accurate measurement. I stepped out onto the porch. "Can I help you with something?" Margaret jumped, clearly not expecting me to be home. "We're conducting an official inspection of the property. You have permission to be on my property." As HOA board members, we have the right to inspect properties for covenant compliance. Patricia had already briefed me on this. "Actually, you don't. Georgia law requires you to provide 24 hours written notice before entering private property, and I have the right to be present during any inspection. You're currently trespassing." Richard stepped forward. Now, let's not be unreasonable here. I'm not being unreasonable. I'm citing Georgia property law. You need to leave. Margaret's face turned that particular shade of red that indicated a full Karen meltdown was incoming. You are in violation of multiple covenants, Mr. Sullivan. Your attitude is not helping your case. My case is supported by state and federal law. Yours is supported by an HOA covenant that illegally attempts to override historic preservation statutes. Now please leave my property. They left, but not before Margaret promised that this wasn't over. I immediately called Patricia and told her what had happened. Good, she said. Let them keep digging their hole deeper. Every illegal action they take strengthens your case. The following Monday, I received notice that the HOA was scheduling a special hearing to discuss my violations. The hearing was set for Thursday evening at the community center. Attendance was mandatory, the letter stated, or I would be found in automatic violation and fines would begin immediately. Patricia advised me to attend but to say as little as possible. Let them talk. Let them make their arguments. We're building a case here, and I want them on record. I spent the days before the hearing gathering more documentation. Daniel connected me with Dr. Raymond Foster, a historic preservation professor at the Savannah College of Art and Design, who agreed to provide an expert opinion on the significance of my property. His 10-page letter was a masterpiece of academic authority, detailing the architectural significance of every element Margaret wanted me to change. Thursday evening arrived, and I drove to the community center with a briefcase full of documents and Patricia by my side. The hearing room was set up like a courtroom, with the board sitting at a long table at the front and rows of chairs facing them. About 20 other residents were scattered throughout the audience, clearly there to watch the drama unfold. Margaret sat in the center of the board table, flanked by Richard, Susan, and 2 other board members I didn't recognize. She had a gavel, which seemed unnecessarily dramatic. "This hearing will come to order," Margaret announced, tapping the gavel with more force than necessary. "We are here to address multiple covenant violations at 847 Habersham Street, owned by Mr. Jake Sullivan. Mr. Sullivan, you and your counsel may sit in the front row." Patricia and I took our seats. I noticed several people in the audience craning their necks to get a better look at me, whispering to each other. Margaret began reading from a prepared statement. "The homeowner at 847 Habersham Street has repeatedly and willfully violated HOA covenants regarding exterior paint colors, fence specifications, unapproved signage, and non-conforming landscaping. Despite multiple notices, the homeowner has refused to comply. The board is considering imposing immediate daily fines of $1,500 until compliance is achieved." She looked directly at me. "Mr. Sullivan, would you like to address the board?" Patricia stood. Patricia Zhang, representing Mr. Sullivan. "Before my client addresses these accusations, I'd like to present several documents for the board's consideration." Margaret's expression soured. "This is an HOA hearing, not a legal proceeding. We don't need lawyers here." "Mr. Sullivan has the right to legal representation, as established in Georgia case law. I'm going to present these documents whether you like it or not." Patricia walked forward and placed packets in front of each board member. "These documents include letters from the State Historic Preservation Division, the Coastal Georgia Historical Society, and the National Trust for Historic Preservation. They also include relevant state statutes and federal regulations regarding historic landmark properties. I suggest you read them carefully before proceeding with any fines." Margaret barely glanced at the documents. We've already reviewed the claim that this is a historic property. That doesn't exempt Mr. Sullivan from his contractual obligations to the HOA. Actually, it does, Patricia said calmly. Georgia Code Section 44-1024 explicitly states that HOA covenants cannot require alterations to properties listed on the National Register of Historic Places if those alterations would compromise the property's historic integrity. Mr. Sullivan's home is not only on the National Register, it's also protected under federal law through the National Historic Preservation Act of 1966. We have our own legal counsel, Richard interjected, and they've assured us that our covenants are enforceable. Then your legal counsel is incompetent, Patricia said flatly. And if you proceed with these fines, you'll be opening the HOA to a lawsuit for harassment, illegal restraint, and violation of state and federal law. The damages could be substantial. Susan spoke up for the first time. But he signed the covenant. Everyone who buys in this neighborhood signs it. A contract that requires illegal activity is unenforceable, Patricia explained. You can't sign away your rights under state and federal law. If I had you sign a contract agreeing to commit murder, that wouldn't make murder legal. The same principle applies here. Margaret's knuckles were white as she gripped her gavel. This is ridiculous. We're not asking Mr. Sullivan to commit murder. We're asking him to paint his shutters an appropriate color and trim his fence. I decided it was time to speak. Margaret, those shutters are made of old-growth cypress that's over 130 years old. They were painted using historical paint analysis to match the original 1887 color scheme. If I paint them colonial blue, I'll be destroying irreplaceable historic fabric. The fence was forged by hand in 1892. It's one of only 3 remaining examples of that blacksmith's work in the entire state. I don't care about any of that, Margaret said, her voice rising. This is about property values and community standards. Your house looks different from every other house in the neighborhood, and that affects all of us. It looks different because it's 140 years older than most houses in this neighborhood, I shot back. It was here first. That's not the point, Patricia held up a hand. Actually, that's exactly the point. The HOA was established in 1998. Mr. Sullivan's house has been a protected historic landmark since 1982. The HOA covenant should never have included his property in the first place. In fact, we believe the inclusion of a registered historic landmark in an HOA with restrictive covenants was a mistake during the original subdivision filing. This caused a stir among the board members. They huddled together, whispering urgently. After a few minutes, Margaret called for a 15-minute recess. Patricia and I stepped outside. That went well, she said with a slight smile. They're not going to give up. No, probably not, but we've planted seeds of doubt. At least some of those board members are starting to realize they could be personally liable if this goes to court. When we reconvened, Margaret's demeanor had changed slightly. She was still hostile, but there was a hint of uncertainty in her voice. The board has discussed the matter. We acknowledge the historic nature of the property. However, we maintain that certain standards can and should be upheld regardless of historic designation. We're willing to negotiate on the shutters and the fence, but the historical markers must be removed and the landscaping must be brought into compliance. No, I said firmly. Margaret blinked. Excuse me. No. I'm not removing the historical markers that were placed by the historic Savannah Foundation. I'm not changing my historically accurate garden. I'm not painting my shutters, and I'm not altering my fence. This property is a landmark, and it's going to stay true to its historic character. Then we have no choice but to impose fines, Margaret said, her voice shaking with anger. Patricia stood again. If you impose any fines, we will immediately file for an injunction in Chatham County Superior Court. We'll also be filing a complaint with the Georgia Department of Law, Consumer Protection Division, for HOA abuse. And we'll be notifying the National Trust for Historic Preservation that a local HOA is attempting to destroy a nationally significant landmark. I guarantee you that the media attention alone will be devastating for your organization. The room fell silent. I could see the wheels turning in the board members' heads. Richard leaned over and whispered something to Margaret. Susan looked genuinely worried. "We'll need to consult with our attorney," Margaret finally said. "This hearing is adjourned. The board will issue its decision within 10 business days." As Patricia and I left the community center, I felt a mixture of relief and exhaustion. "Do you think they'll back down?" "Hard to say. Margaret seems like the type who'd rather burn the whole thing down than admit she's wrong. But the other board members looked nervous. They might overrule her." The next morning, I got an unexpected call from a reporter at the Savannah Morning News. Her name was Jennifer Matthews, and she had heard about the dispute. "Mr. Sullivan, I'm doing a story on historic preservation challenges in Savannah's suburban neighborhoods. I understand you're facing pressure from your HOA to alter a registered landmark." I hesitated, unsure if talking to the press was a good idea. "Can I call you back? I need to check with my attorney." "Of course. But I should let you know I've already spoken with the Coastal Georgia Historical Society and the Historic Savannah Foundation. They both gave me quite an earful about this situation. I'm calling you to get your personal perspective." After hanging up, I immediately called Patricia. "The press is calling. Should I talk to them?" "Absolutely. This is exactly the kind of pressure the HOA board needs. Just stick to the facts, be respectful, and emphasize the historic significance of the property." I called Jennifer back and spent 45 minutes on the phone with her, walking through the entire timeline. She asked detailed questions about the restoration process, the cost, and the HOA's specific demands. "This is fascinating," she said. "I've been covering development issues in Savannah for 10 years, and this is one of the more egregious cases I've heard. Would you be willing to let our photographer come take pictures of the property?" "Sure." "When?" "How about tomorrow morning?" The article ran on Sunday, taking up half of the front page of the local section. The headline read, "Historic Home Faces HOA Threat. 1887 Landmark Caught in Preservation Battle." The photographs were stunning, showing the intricate details of the shutters, the ornate fence, and my Victorian garden in full bloom. Jennifer's article was balanced but devastating for the HOA. She had gotten quotes from Daniel, Rebecca Chen at SHPD, and Dr. Foster from SCAD, all emphasizing the national significance of the property and the illegality of the HOA's demands. She had also reached out to Margaret for comment. Margaret's quote was pure gold. "Mr. Sullivan needs to understand that being part of a community means following community rules, regardless of personal circumstances. His home may be old, but that doesn't make him special." The article immediately sparked outrage on social media. The Historic Savannah Foundation shared it on their Facebook page, where it received hundreds of comments supporting my position. Preservation groups across Georgia picked up the story. By Monday afternoon, I was getting calls from reporters in Atlanta, and even one from a national public radio program about preservation issues. But the story also energized Margaret's supporters. On Tuesday, I found a letter in my mailbox, not from the HOA officially, but from a group calling themselves Concerned Residents of Magnolia Heights. The letter, signed by 15 people, accused me of being elitist, of caring more about old buildings than my neighbors, and of deliberately stirring up trouble. Your insistence on special treatment is dividing our community, the letter read. If you wanted to live in a historic district, you should have bought a house in the Victorian district downtown, not in a modern neighborhood with reasonable standards. I felt a flash of anger. My house had been built decades before this modern neighborhood existed. The subdivision had grown up around the historic properties, not the other way around. That evening I was working in my garden when a car pulled up. A man in his 60s got out, walking with a slight limp. He had kind eyes and a weathered face. "Mr. Sullivan, I'm Tom Patterson. I live a few streets over." "Hello," I said cautiously, not sure if this was a friendly visit or another confrontation. "I just wanted to say I think what you're doing is great. My grandfather was a carpenter who worked on historic homes in Savannah back in the 1950s and 60s. He would have loved what you've done with this place." I felt some of the tension leave my shoulders. "Thank you, that means a lot. Margaret doesn't speak for everyone in this neighborhood. A lot of us are proud to have historic properties here. It gives the community character." He paused. "I also wanted to warn you. Margaret's husband is on the City Planning Commission. They're well connected and they don't like to lose. I appreciate the heads up. Good luck. And if you need neighbors to speak up for you, let me know. I can get a few signatures." After Tom left, I felt slightly better. At least I wasn't completely alone in this fight. The 10-day deadline for the board's decision came and went with no word. On day 12, I received a letter from a law firm in Atlanta, representing the HOA. The letter was technical and aggressive, arguing that the HOA covenant was enforceable and that my failure to comply would result in fines, potential legal action to force compliance, and possible foreclosure on my property for unpaid fines. Patricia was unfazed. "Foreclosure? They're delusional. Let them try. We'll bury them in countersuits." She drafted a response that was equally technical and twice as aggressive, citing case after case where HOAs had lost when trying to enforce covenants that conflicted with historic preservation law. But the stress was getting to me. I had trouble sleeping, and I found myself constantly checking my mailbox for new violation notices. The joy I had felt during the restoration process was being replaced by anxiety and frustration. Then something unexpected happened. On a Wednesday morning in late May, I received a call from a woman named Helen Cartwright. She identified herself as an attorney with the National Trust for Historic Preservation in Washington, D.C. "Mr. Sullivan, we've been following your situation with great interest. The National Trust is prepared to intervene on your behalf." I almost dropped the phone. "Really?" "Absolutely. Your case represents a growing problem across the country. HOAs are increasingly targeting historic properties, either out of ignorance or malice. We need to establish clear precedent that federal landmark protection supersedes local covenant restrictions." "What does intervention mean, exactly?" "It means we're going to file an amicus brief supporting your position if this goes to court. We're also going to put pressure on the HOA through official channels, and we're prepared to make this a national test case if necessary." "Is that good or bad for me?" Helen laughed. "Good, very good. It means you have the resources of one of the largest preservation organizations in America behind you. It means the HOA is now facing not just state pushback, but federal attention. And it means they're going to think very carefully before continuing this fight." After hanging up with Helen, I called Daniel to share the news. "That's incredible, Jake. The National Trust doesn't get involved in local disputes unless they think there's something significant at stake. This validates everything you've been fighting for. I'm honestly overwhelmed. I just wanted to restore a beautiful old house. I didn't expect to become a test case for historic preservation law. Sometimes that's how it works. You're fighting the good fight, whether you meant to or not. The National Trust's involvement changed everything. Within days, I received a formal letter from the organization, beautifully written on official letterhead, detailing their support and outlining the legal framework for landmark protection. They sent copies to the HOA, the State Historic Preservation Division, and the Georgia Attorney General's office. The response from the HOA was delayed but telling. 2 weeks after the National Trust's letter, I received a notice that the board was calling for a special election to recall Margaret as president. The notice didn't give specific reasons, but the implication was clear. The other board members were distancing themselves from her aggressive stance. Margaret, however, wasn't going down without a fight. She started showing up at neighborhood association meetings, giving presentations about property rights and contractual obligations. She circulated petitions demanding that I either comply with the covenant or sell my house. The recall election was scheduled for mid-June. In the weeks leading up to it, the neighborhood became a battleground. Signs appeared in yards, some saying "Preserve our history," others saying "Uphold our covenants." Tom Patterson kept his promise, collecting signatures from residents who supported my position. He delivered a petition with over 60 names to the HOA office, demanding that they drop all violations against my property. Margaret fired back with her own petition, claiming over 100 signatures demanding enforcement of the covenants. The local news picked up the story again, this time framing it as a neighborhood divided over growth versus preservation. Jennifer Matthews wrote a follow-up article featuring interviews with residents on both sides. One woman, who lived in a modern McMansion 3 streets over, told Jennifer, "I paid good money to live in a nice, uniform neighborhood. Mr. Sullivan's house sticks out like a sore thumb. I don't care if it's historic, it ruins the aesthetic." Tom countered in the same article. "Jake Sullivan saved a piece of Savannah's history. That house was rotting away for years. He should be thanked, not harassed." The day of the recall election arrived. I wasn't allowed to vote since the election was for board positions, but Patricia advised me to attend the meeting as an observer. The community center was packed. Over 150 residents showed up, filling every seat and lining the walls. The tension in the room was palpable. Margaret stood at the front, defending her tenure as president. "I have worked tirelessly to maintain property values in this neighborhood. I have enforced our standards fairly and consistently. If we allow one resident to ignore our covenants, even for supposedly historic reasons, we open the door for everyone to claim exceptions. Our community will become chaotic." She was actually a compelling speaker, and I could see some heads nodding in agreement. Then a woman I didn't recognize stood to speak. She was elderly, probably in her 80s, with white hair pulled back in a bun. "My name is Dorothy Sheffield. I've lived in Savannah for 60 years. I'm a retired architectural historian, and I spent 30 years working for the Georgia Historical Society." Her voice was strong despite her age. "What Margaret is proposing isn't just wrong, it's illegal. Mr. Sullivan's house is one of fewer than a dozen remaining examples of high-style Victorian architecture from that period in this part of Georgia. Forcing him to alter, it would be cultural vandalism. I'm ashamed that our HOA has pursued this vendetta." The room erupted in applause from about half the attendees. The other half sat in stony silence. The vote was called. Out of 142 votes cast, Margaret was recalled by a margin of 79 to 63. It wasn't a landslide, but it was decisive. Richard was elected as the new president, and in his acceptance speech, He promised to find a reasonable resolution to ongoing disputes while respecting both community standards and legal obligations. After the meeting, Richard approached me. "Mr. Sullivan, I'd like to schedule a meeting with you and your attorney next week. I think we can work something out." "I'm willing to talk," I said carefully, "but I'm not changing my house." "I understand. We'll find a compromise." The meeting took place the following Tuesday at the HOA office. Richard attended, along with Susan and a new board member named Mike, who seemed genuinely interested in history. Patricia came with me, along with Daniel from the Historical Society. "Here's what we're proposing," Richard began. "We acknowledge that your property has special historic status. We're willing to grant a permanent exemption from all covenant restrictions related to historic features, including colors, materials, architectural details, and historically appropriate landscaping." I felt a wave of relief. "That sounds reasonable." "In exchange," Richard continued, "we'd like you to agree to maintain the property to high standards, allow occasional educational tours coordinated through the Historical Society, and perhaps consider adding a small plaque explaining the exemption so other residents understand the situation." I looked at Patricia, who gave a small nod. "I can agree to that," Daniel spoke up. "The Historical Society would be happy to coordinate tours. In fact, we've been wanting to add more historic properties to our annual Heritage Tour. Jake's house would be a perfect addition." We spent another hour working out the details. The agreement would be formally recorded and attached to my property deed, ensuring that future HOA boards couldn't revisit the issue. In return, I agreed to join the Neighborhood Historical Committee, which would help educate residents about the area's history. As we were finalizing the agreement, I decided to ask the question that had been bothering me. Why was Margaret so fixated on my house? "There are other historic properties in the neighborhood," Richard sighed. "Between us, her daughter wanted to buy your house before you did. They were in negotiations when your offer came in higher. Margaret took it personally. This was never really about covenants, it was revenge." I felt a cold anger at that revelation. She tried to force me to destroy historic features because of a real estate grudge. Like I said, that's between us. But yeah, that's what I believe. "Does that change your willingness to sign this agreement?" Susan asked nervously. I thought about it for a moment. No, this agreement is the right thing regardless of Margaret's motivations, but I want it noted somewhere in the official record that this dispute should never have happened. Patricia added, "And we reserve the right to pursue civil remedies against Margaret personally if evidence emerges that she abused her position for personal reasons." Richard nodded. "Fair enough." The agreement was finalized and signed on June 28th, almost 3 months after Margaret's first violation notice. The HOA issued a formal apology, posted on their website and sent to all residents, acknowledging that the violations against my property were issued in error, and that historic landmark properties would be treated differently going forward. The story might have ended there, but Margaret couldn't let it go. She started posting on neighborhood social media groups, accusing me of bullying the HOA with lawyers and outside organizations. She claimed I had cost the HOA thousands in legal fees and created division in the community. Her posts got increasingly unhinged over several weeks. She started making claims that I had bribed officials at the Historical Society, that my restoration wasn't authentic, and that I was planning to turn my house into a commercial bed and breakfast despite zoning restrictions. None of it was true, but the posts were damaging my reputation. Patricia advised sending a cease and desist letter. Margaret ignored it. Instead, she escalated. In late July, I woke up to find that someone had spray-painted "Liar" across my original wrought iron fence. The paint was bright red, stark against the black iron. I called the police immediately. The responding officer, a patient man named Officer Davis, took photographs and a statement. He also checked my home security cameras, which had captured a figure spray painting the fence around 2:30 a.m. The person was wearing dark clothing and a hood, making identification difficult. "I can't tell who it is from this footage," Officer Davis said, "but you should definitely keep this recording. If there are more incidents, we might be able to establish a pattern." I spent the next day carefully removing the spray paint, using gentle solvents that wouldn't damage the historic iron. It took 8 hours of painstaking work. 2 weeks later, it happened again. This time, someone had dumped a bucket of white paint across my Victorian garden, killing several heritage rose bushes that had cost me hundreds of dollars and months of searching to find. Officer Davis came back out. "Mr. Sullivan, this is escalating to vandalism and property destruction. Have you had ongoing conflicts with anyone?" I told him about the HOA dispute and Margaret's recent social media campaign. He took notes and said he'd follow up. 3 days later, the police had a break. A neighbor 2 houses down had a doorbell camera that captured a car driving slowly past my house around the time of the paint incident. The car was registered to Margaret's husband. Officer Davis came to my door with a detective named Sarah Morrison. "Mr. Sullivan, we have reason to believe Margaret Henderson may be involved in the vandalism to your property. We're going to question her. What happens if she did it? That depends on the value of the damage and whether we can prove intent. But vandalism of historic property could carry enhanced penalties under Georgia law." 2 days later, Margaret was arrested. According to the police report, her husband's car had been captured on multiple security cameras in the neighborhood on both nights. When confronted, Margaret initially denied everything, but then broke down and admitted to the vandalism. She claimed she was defending her community against an outsider who didn't respect their rules. The charges were serious. 2 counts of criminal damage to property, both enhanced to felony level because of the historic designation of my property, and the total damages exceeding $1,500. There was also a harassment charge related to her social media campaign. The arrest made the local news again. Jennifer Matthews called me for comment. "I'm sad it came to this," I told her honestly. "I just wanted to restore a beautiful piece of Savannah's history. I never wanted anyone to be arrested or for the neighborhood to be torn apart. Do you feel vindicated?" I thought about that. Not really. Vindication would be if this had never happened in the first place. Mostly I feel exhausted. The legal process moved slowly. Margaret's attorney tried to get the charges reduced, arguing that she had been under stress and that the damage wasn't as extensive as claimed. But the prosecutor had expert testimony from Daniel and Dr. Foster about the value and significance of the damaged elements. In October, Margaret accepted a plea deal. She pled guilty to 2 misdemeanor counts of criminal damage to property. She was sentenced to 2 years probation, 200 hours of community service at historic preservation sites, restitution of $4,800 for the damage to my fence and garden, and a prohibition on serving on any HOA board during her probation. The judge, an older black woman named Judge Teresa Williams, had strong words during the sentencing. "Miss Henderson, you took a position of community trust and abused it for personal revenge. Your actions could have resulted in the destruction of irreplaceable historic architecture. You then compounded your misconduct with criminal vandalism. You're fortunate that Mr. Sullivan's security measures and the diligent work of our police department prevented further damage. Historic preservation is not a matter of personal preference. It's a matter of protecting our shared cultural heritage. I hope your community service will teach you to value that heritage. I attended the sentencing with Patricia. As we left the courthouse, reporters asked if I was satisfied with the outcome. "I'm satisfied that justice was served," I said carefully. "But my real hope is that this case serves as a warning to other HOAs. You can't bully homeowners into destroying historic properties, no matter how much you dislike seeing something different in your neighborhood." The story had one final chapter. In November, the Coastal Georgia Historical Society held a special ceremony at my house. They presented me with an award for historic preservation and announced that my property would be featured in their 2027 guidebook to Georgia historic homes. Over 100 people attended, including city officials, preservation advocates, and neighbors from Magnolia Heights. Richard gave a short speech about the importance of learning from mistakes. Tom Patterson gave me a bottle of bourbon and a handshake. Daniel pulled me aside during the reception. "You know, when you first called me back in April, I thought this would blow over quickly. I never imagined it would turn into all this." "Neither did I admitted. "I just wanted to drink coffee on my porch and enjoy my house." "Well, you've done more than that. The case you've built has already been cited in 2 other HOA disputes in Georgia. You've created precedent that's going to protect historic properties for years to come." Standing on my porch that evening, watching the last guests leave as the sun set over Savannah, I felt a deep sense of peace. The shutters that Margaret had wanted me to paint gleamed in their original dark green. The wrought iron fence, now repaired and restored after the vandalism, caught the golden light. My Victorian garden, replanted with heritage roses, was preparing for winter dormancy. The house had survived 138 years of history: the Civil War aftermath, Reconstruction, the Great Depression, hurricanes, economic decline, and urban decay. It had survived because people along the way had recognized its value and fought to preserve it. I was just the latest in that line of caretakers, and I had done my part. The house would be here long after I was gone, a testament to 19th century craftsmanship and to the importance of protecting our architectural heritage. Margaret's attempt to force modern conformity on a historic landmark had failed. The law, the historic preservation community, and ultimately the justice system had recognized that some things are more important than HOA covenants and personal grudges. I went inside, poured myself a drink, and sat in my restored parlor surrounded by original moldings, heart pine floors, and the weight of history. Tomorrow I would start planning the spring garden. I would continue documenting the house's history. I would give tours to students and history enthusiasts. But tonight, I would simply enjoy living in a piece of living history, knowing that it was protected not just by my ownership, but by law, precedent, and the collective recognition that our past deserves to be preserved. The fight had been exhausting, expensive, and stressful, but it had been worth it. Every original shutter, every hand-forged fence picket, every carefully restored architectural detail represented a victory not just for me, but for everyone who believes that historic preservation matters. Margaret would spend the next 2 years on probation, hopefully learning to appreciate the very history she had tried to destroy. The HOA had learned that covenants have limits. And I had learned that standing up for what's right, even when it's difficult, can create change that extends far beyond your own property line. As I climbed the original 1887 staircase to my bedroom that night, running my hand along the carved walnut banister, I thought about Captain James Sullivan, the original builder. I like to imagine he would have approved of the fight I had waged to protect his creation. The house settled around me with the creaks and groans of old wood and plaster, sounds that connected me to more than a century of previous occupants. This wasn't just my home. It was a landmark, a piece of American history, and now, thanks to everything that had happened, it was protected from future threats. The Karen who called violations on my landmark property had learned a hard lesson. The Historic Society had sided with me. The state had sided with me. Federal preservation law had sided with me. And ultimately, even the justice system had sided with me. But more importantly, the house itself had won. It would stand for another century or more, a monument to skilled craftsmanship and the enduring value of preserving our architectural heritage. And that, in the end, was all that really mattered.